Well, I just thought I needed, your help with some counterclaims.
Well, I don't help people with counterclaims. I'm a judge. I'm the neutral party here.
Okay, so what do we do next?
So we go through and I'm going to rule on these objections.
And hello,
and so
good morning.
far
I'm calling this case, which is Matthew Reed versus Donna Snethkamp. And this is case number 2501153 RGC. We're here for a pretrial today. Matthew Reed, you're here on Zoom. Can you please confirm that you can hear and see me?
Yes, I can, Your Honor.
Okay, thank you. And Donna Snethkamp, you're here also. You're on your telephone only. Ms. Snethkamp, can you please confirm you can hear and see, or you can hear me and Mr. Reed?
Yes, very clearly, Your Honor.
Okay,
Yes.
and we are here for a pretrial today. This was a matter that originally was a small claims matter that has been removed to the General Civil Division. Ms. Snethkamp has also filed a jury demand, and you have filed some objections, Ms. Snethkamp, to the court's pretrial scheduling order. Is that correct?
Yes.
Okay, so we have a jury trial has not yet been set. We don't have a date for jury selection and final pretrial, but we can, that will be something to address here today at this pretrial. But Mr. Reed, you have received Ms. Snethkamp's objections to the scheduling order?
Yes, Your Honor.
Okay, so Ms. Snethkamp, what would you like to state in terms of your objections? I know you have issues you'd like to discuss in terms of discovery. Is that correct?
Yes, and I have my attorney here with me, David Naisman.
Okay, well, that's extremely important. I shouldn't be talking to you directly. Do we have an attorney that's filed an appearance in this matter? No attorney has filed an appearance.
No, Your Honor. I have been working with my my state bars to get my documentation, and under the current Michigan law, I need to file with them before the motion is filed with the court. That was done on Friday, and as soon as I get the original signed motion from my sponsoring attorney, that'll be filed with you by at least I would think tomorrow.
Okay, well, you're not a licensed practicing attorney in the state of Michigan right now, is that correct?
That's correct. I'm
okay. So you don't have a lawyer,
for...
Ms. Snethkamp. You don't have a lawyer. And
okay.
I don't know anything about any of what your lawyer has, what you're alleged or, the purported attorney is saying here, because I don't have any of that documentation before me. So,
okay.
Ms. Snethkamp, we're here today for your objections. So nothing about my order that I signed is certainly is not improper under the court rules, and it is typically it's standard scheduling order for a matter like this. So what do you want to object to as to the court's order?
Would you mind if David spoke to this for me, to you?
I would mind, because he's not an attorney and he can't appear on behalf of you.
The defendant asks if her so-called attorney can speak on her behalf. But the judge immediately stops the request in its tracks. Without a valid law license and court approval, no one can argue the case. The courtroom isn't a place for unofficial legal representation. The judge makes it crystal clear that rules apply to everyone. One firm ruling changes the entire direction of the hearing.
Appear on behalf of you, and no, he absolutely cannot, and I think allowing him to do so could be problematic for him. He cannot appear as a lawyer because he's not a licensed attorney.
So what was the question again? I'm sorry.
So, Ms. Snethkamp, and I'm looking at my order, paragraph 9. Any party can file objections to its content within 14 days. My order was issued on May 28th. You filed your objections on June 16th. I don't think that they were timely filed.
Boy, we thought they were. I thought that I brought that all in there.
Okay, well, again, they were received by the court on June 16th. So, Ms. Nethke, if we have a problem in terms of the timeliness of the objections, the court could, of course, overlook that in the interest of justice. But what you're asking, I'm looking at your objections, you're asking that the court allow discovery. And you want all discovery that would be permitted within a reasonable period. The court does not typically order discovery, full discovery like that, nor am I need to in district court. Right now I have two unrepresented parties, and the court does not typically order discovery when I have two people who are not represented by lawyers. So do you have anything more to say in terms of your objection to discovery?
Well,
And Mr. Whoever you are, I do not want to hear you advise a person that you're not their lawyer.
well, he was just showing me the paper that this was filed. I brought it in, and it said to file it within 14 days after I received it. So I'm just stuck on that.
Okay, so when did you receive the scheduling order?
Oh, it was probably, I don't have that exact date in front of
Okay.
me here, but you know,
Okay, and I'm saying
I'm-
I can look past the timeliness, but why should I order discovery? That is not the typical practice, and the court rules don't require it. Mr. Reed is not represented by a lawyer. You're not represented by a lawyer. Discovery is typically not ordered in these circumstances.
well, and I thought that was all included in the filing, you know, some of the objections, if we can go back and go over that.
And I'm looking at your objections and I'm saying, is there anything else you want me to know? Because right now I'm going to overrule your objection.
You know, I'm 70, going on 75 years old, and it all just becomes boggled in my head. I'm sorry.
Okay,
But
so
I guess
it doesn't seem like we're going to be able to, that objection for discovery is overruled. Your second objection had to do to discover. I think all of these, I mean, if we're having a trial, the court rules require that all exhibits must be exchanged and between the parties in advance of trial, and we will definitely address that. But that we don't need discovery to do that. So a lot of the things that you're asking for in terms of a veterinarian report and billing and something about animal control. I mean, if plaintiff, Mr. Reed, intends to admit any of that at trial, he needs to make sure that you have those exhibits in advance of trial.
I see. So I don't understand. I've never been, you know, I've never been in a court situation myself before. So this is all
As
really.
the hearing continues, the defendant admits she's overwhelmed. She explains she's never been through a court case before. The judge remains respectful but reminds her that the court cannot provide legal advice. Choosing a jury trial also means accepting more complex legal procedures. Every decision carries responsibilities that can't be ignored. The courtroom becomes a tough lesson in how the legal system really works.
Before, so this is all really new to me. So
Okay,
just-
well, you've asked for, I mean, this started as a matter where it was much more easy to navigate for an unrepresented person. And then you removed it to the general civil division where the court rules apply. And now you've asked for a jury trial. So all these things make the case more procedurally complicated. So, but that is your doing, and you have every right to do that, but I can't help you navigate this now. So you've asked
Okay,
for,
well, I just thought I needed, your help with some counterclaims.
well, I don't help people with counterclaims. I'm a judge. I'm the neutral party here.
Okay, so what do we do next?
So we go through and I'm going to rule on these objections. And so far I'm overruling and denying all of your objections. It does appear to the court that the jury trial, demand for a jury trial was timely made. So we have a demand for a jury trial. So what that means, Ms. Snethkamp and Mr. Reed, is that this will be set for a jury selection. And you both need to be prepared to pick a jury and follow the court rules for picking a jury. And then after that, we would get a date for a jury trial.
Okay, thank you.
And then we also need to, for this pretrial, the court is ordering that all exhibits, so anything, and that would be a document, a photograph, any kind of copies of emails, etc., anything that the parties would wish to admit a trial and have the jury consider, those documents need to be exchanged between the parties. And I'm ordering that needs to happen in the next 2 weeks.
2 weeks, okay.
Yes. So today is the 6th. All exhibits will need to be exchanged between the parties by July 21st.
Okay,
And then Ms. Horn will be looking at the August. Okay, so August 10th is our date for final pretrial. That requires both parties in-person appearance. And that's at 9:30 a.m. Excuse you?
oh, I'm sorry, but that's in East Lansing?
That is the East Lansing 54B District Court.
Okay.
And then jury selection is on August 11th at 1 p.m. So, Ms. Snethkamp, I'm ordering that you submit an order to this court that memorializes and puts into writing my order today. 1, all of your objections have been overruled. And
Okay.
2,
I'm writing this down.
okay, and 2, your parties must exchange exhibits by July 21st.
Okay, July 21st.
And then the court will see both parties for final pretrial in person on August 10th at 9:30. Anything further, Mr. Reed?
No, Your Honor, not at this time. So to confirm, August 10th will be a final pretrial. Your Honor, can you confirm the difference between this pretrial and then the final
Sure.
pretrial?
So final pretrial is the day right before jury selection. So the final pretrial requires in-person appearance. So we'll be here at the court. And at that point, the court will review, first make sure all of the exhibits have been exchanged, that the parties are ready to proceed to jury selection, that there's no, any final negotiations have ended. There's no negotiations, there's no possibility of a resolution, and we are going to trial. So that's what that final pretrial. So you'll be expected to, if you think it would be productive, you and defendant can speak before the hearing. You'll both be asked on about those questions in terms of a resolution, and then we'll do all of make sure that the court's orders have been fulfilled in terms of exhibits. Witness lists, you'll need to have any witnesses that you tend to call. Those will have to be provided to the court and to the other party, and that you are ready to proceed with jury selection the next day.
Understood. And my last
Okay.
question, Your Honor,
Yeah.
if I may. So the defendant's attorney, currently not a licensed state attorney, he has not filed a Pro Hoc VG, and nor has he filed a motion to appear today.
No.
All of those things need to take place in order for this to move forward on August 10th. Is that correct?
With every objection denied, the judge turns the focus toward trial preparation. Both sides are ordered to exchange all evidence before the deadline. The judge warns that anyone appearing without proper legal representation must represent themselves. The final pretrial and jury selection dates are officially scheduled. There are no more shortcuts and no more excuses. Now the next stop is a courtroom jury ready to hear the entire case.
On August 10th, is that correct?
No, I mean, right now, the attorney, I don't have anything before me other than Ms. Snethkamp's, assertion. She says it in her objections, but also on the record here today that she intends to have an attorney, a licensed attorney, appear for her. That hasn't happened. And unless and until it does, she is unrepresented and she needs to be prepared to represent herself at those hearings in August.
Understood. Thank you, Your Honor.
Okay. Ms. Snethkamp, anything further from you?
No. I'm sorry I couldn't figure out how to do the Zoom here. I tried that at mitigation, but I'm just having some problems with equipment. All right. No, I understand. I've been taking notes, so I appreciate your time. Thank you so much.
Okay. Thank you very much.